Hello friends, today's topic is on capacity to contract. In this topic, we are going to discuss the minors agreement, nature of minors agreement, effect of minors agreement, minors liability in torts, contract of apprenticeship, necessaries supplied to a minor, and persons of unsound mind. One of the essential requirements of a valid contract is that the parties must be competent to contract. Section 10 of the Contract Act provides all agreements or contracts, if they are made by the free consent of the parties competent to contract for lawful consideration and with a lawful object and are not expressly declared to be void. Section 11 describes the persons who are competent to contract. It provides every person is competent to contract who is of the age of majority according to law to which he is subject and who is of sound mind and is not disqualified from contracting by any law to which he is subject. In the law of contract, persons below the age of majority were formerly called infants. They are now more generally called minors. The Indian Majority Act was amended in 1999 and the age of the majority is now 18 in all cases, even if the guardian for minor's property or person has been appointed by the court. But the question whether the person under the 18 years are bound by the contract can still arise today. For example, in case of contract for a benefit of minor or necessaries supplied to minor goods or services. Legal problem can also arise where a claim is made by the minor against another party, either to enforce the contract or to reclaim money or property the minor has parted with. The law on this subject is based on two principles. The first and the most important is that the law must protect the minor against his inexperience, ignorance and immaturity, which may enable an adult to take an unfair advantage of him or to induce him to enter into contract. The second principle is that the law should not cause unnecessary hardship to adults who deal fairly with minors. Explaining the extent of the Section 11, which deals with the persons who are competent to contract, the Gujarat High Court in Shantiniketan Cooperative Housing Society Limited versus District Registrar Cooperative Society held that there is no prohibition under Section 11 of the Indian Contract Act for the foreign citizen to become a party to a contract. Section 11 requires that party to contract must be age of majority according to law to which they are subject and should not be disqualified from contracting. According to Section 11, following persons are competent to contract: who is of the age of majority, who is of sound mind, and who is not disqualified from contracting according to law to which he is subject. Minors agreement. The age of the majority is generally 18 after the Indian Majority Act was amended in 1999. Earlier, it was 21 years when a guardian to a person or a property of the minor was appointed. Now, a minor became a major when he is of 18 years in all cases. In England, any person below the age of 21 years is a minor. But in India, two limits of 18 and 21 were prescribed for minor and a minor under the Code of Wards. There are some inconveniences caused by these two categories created under law. Example, it is possible for a person over 18 years to enter into an agreement without disclosing that in law he is minor, being a ward of the court. The person who deals with such persons is put to difficulty of making sure if he is not in ward of the court. The reason of the age limit of 21 years was that where a dispute arises as to the management of the property of a minor, a court would like to safeguard the property till the minor attains the age of 21 years. This inconvenience has been removed by 1999 amendment and now in all cases age of majority is 18 years. Law to which he is subject. The capacity to enter into an agreement depends upon the law of the place where the contracting party is domiciled. But there is a tendency not to accept this law of domicile. In Keshaba versus Shripat, a Hindu widow executed a bond in Kolhapur where she was just over 16 years. She lived with her husband who domiciled in British India. Her husband died but widow continues to live in the same place. She had the domicile of her husband, and the court held that a bond executed by her when she was less than 18 was not valid, since no minor is bound by such contract under Section 11. Though under Kolhapur law, the age of majority was 16 years. Nature of minor's contract. Section 11 clearly provides that a minor is not competent to enter into a contract. Is he absolutely incompetent, or is he absolved only from the liability of the contract? If a minor's contract is void, no suit can lie against him, nor can the minor ratify it on attaining majority. Section 11 of the Indian Contract Act is silent about the nature of the minor's contract, and it is not clear whether it is void or simply voidable. There was great controversy in this connection among the Indian High Courts up to 1903. In the year 1903, the Privy Council finally resolved the controversy by declaring that the combined effect of Section 10 and 11 is to make the minor's contract void. This was held by the Privy Council in Mohri Bibi versus Dharmodas Ghosh. The Privy Council held that the minor's agreement is void and not merely voidable on the basis of Section 10 and 11 of the Indian Contract Act. A minor's contract is void ab initio. Under English law, all the contracts entered by the minor are not void. Some are voidable, while the other are absolutely void. Minors are protected by Infants Relief Act, which renders contracts by an infants valid if for the necessaries or for minor's benefit. Void if for the goods supplied to the minor are not for necessaries or money paid by cash. Thus, in England, some of the minor's contracts are merely voidable, whereas others are absolutely void. But in India, minor's contract is void ab initio. The rule of Mohri Bibi was fully applied in the later case of Mir Sarwar Jan versus Fakhruddin. A contract to purchase a certain property of the minor has been made by the guardian on behalf of the minor, and the minor sued the other party for the decree of specific performance to recover possession. His action was rejected. The court said that it was not within the competence either to the manager of the minor's estate or to the guardian of the minor to bind the minor's property. Since the minor was not bound by the contract, the minor could not obtain specific performance of contract. The ruling of the Privy Council in Mohri Bibi's case was generally followed by the courts in India and applied both to the advantage and disadvantage of the minor. In its subsequent pronouncements in Subramaniam versus Subharao, the Privy Council overruled earlier decisions and entertained no doubt that it was within the power of a mother of a minor as a guardian to enter into the contract of sale for the purpose of discharging his father's debts. In the instant case, in order to pay off the promissory note and the mortgage debt of his father, the minor's son and his mother sold a piece of land to the holder of the promissory note and paid the mortgagee accordingly. The possession of the land was given over to him. Afterwards, the minor brought an action to recover back the possession of the land sold to the promissory note holder. The Privy Council held, I quote, "It was found as a fact that the transaction was for the benefit of the minor and the guardian. The capacity to contract on behalf under Section 11 and the Mohri Bibi's case leaves no doubt that the minor cannot contract, and that if mother as a guardian has taken no part in the transaction, it would have been void. The contract being for the benefit of the minor was held to be binding upon him." Unquote. Now, effects of minor's agreement. Number first, fraudulent misrepresentation by minor. Since a minor's contract is void, a pertinent question arises as to what will happen if a minor misrepresents himself to be a major and induced a person to enter into a contract with him, or induced him to lend some money or mortgage his property. Since such a contract is void, it cannot be enforced. Will it imply that the minor's contract in such a case cannot be enforced? Will it imply that the minor in such a case retain the money as well as a property, or he may be compelled to restore the benefits which he has derived under the contract? In Mohri Bibi versus Dharmodas Ghosh, plaintiff, a minor, mortgaged his house in favor of the defendant, a money lender, to secure a loan of Rs 20,000. A part of the money was actually advanced to him. While considering the proposed advance, the attorney who was representing the money lender received the information that the plaintiff was still a minor. Subsequently, it was a minor who commenced his action stating that he was underage when he executed the mortgage and the same therefore should be cancelled. The court was of the opinion that under its discretionary power, it could order restitution against and by the minor, but the court did not order it in the present case because appellant had advanced the loan to the minor while knowing that he was a minor. Restitution. If a minor obtains some property by fraudulently misrepresenting his age, he can be ordered to restore the property or goods thus obtained. This is called the equitable doctrine of restitution. Under English law, minor may be compelled to restore the goods or a property so long as they are traceable and in his possession. Money being generally not traceable, a minor cannot be asked to restore it, because it is very difficult to trace and acknowledge the same notes or coins. This was held in a well-known English case, Leslie versus Shield, wherein the limits of the restitution was explained. In this case, the defendant minor, by fraudulently misrepresenting his age, induced the plaintiff to lend him two sums of $200 each. The plaintiff filed the suit to recover $475 being an amount of the advance with interest. The defendant on the plea of the infancy resisted this action. The court dismissed the suit and pointed out that it was necessary to safeguard the weaknesses of the infants at large, even though here and there a juvenile slipped through. While discussing the suit, Lord Sumner observed, I quote, "When an infant obtained an advantage by falsely stating himself to be of full age, equity required him to restore his ill-gotten gains or to release the party from obligation or acts in the law induced by the fraud, but scrupulously stopped short of enforcing against him a contractual obligation entered into while he was an infant, even by means of fraud. Restitution stops where repayment begins." Unquote. It was also pointed out that the minor is also entitled to repudiate the transactions on attaining majority. Thus, rule laid down in Leslie versus Shield was approved by the Privy Council in Muhammad Said Afrin versus Yesh Oral Grark. The court observed a case of a fraud by the appellant on this subject on his age was set up, but it cannot be doubted that the principle of Leslie versus Shield as applied by the Privy Council in Mori Bivi's case would apply and such case would fail. But in Khangul versus Lakha Singh, the Lahore High Court observed through Shadi Lal, Chief Justice, where a contract of the property is void and such a property can be traced, the property belonging to the promisor can be followed. There is every equity in his favor for restoring the property to him. But where a property is not traceable and the only way of granting compensation would be by a money decree against the minor, then in such a circumstances it cannot be granted as it will lead to validating a contract. Later, Allahabad full bench in Ajodhya Prasad versus Chandan Lal, Justice Sulaiman observed, I quote, "Where the property is not traceable and the only way to grant compensation would be by granting money decree against the minor, decreeing the claim would be almost tantamount to enforce the minor's pecuniary liability under the contract which is void. There is no rule of equity, justice and good conscience which entitle the court to enforce a void contract of minor against him under the cloak of restitution." Unquote. The distinction is too thin to be ignored. The full bench held that mortgage deed cannot be enforced on any such ground. Law Commission, however, favoured the view of Shadi Lal in Khangul versus Lakha Singh. The Section 33 of the Specific Relief Act 1963 was amended by incorporating a provision so as to be in the line with the Shadi Lal's view. The net result of the amendment may be stated in two propositions. Where a void or voidable contract has been cancelled at the instance of the party, the court may require him to restore such benefits as he has received under the contract and to make any compensation to other party which justice may require. Second, where a defendant successfully resists any suit on the ground that a contract by reason of being incompetent is void against him, he may be required to restore the benefit, if any, obtained by him under the contract, but only to the extent which he or his estate has been benefited thereby. Thus, the courts have the discretion to require the minor's plaintiff to restore the benefits obtained under a void contract. In Jagannath Singh versus Lalita Prasad, the court said, when an infant under the age induced other to purchase property from them, they are liable in equity to make restitution to the purchaser for the benefit they have obtained. Therefore, they can recover the possession of the property sold. But the court will not compel the restitution by a minor even when he is plaintiff, where the other party was aware of the infancy so that he was not deceived, or where the other party has been scrupulously in dealing with minor. Principle of Estoppel. If a minor fraudulently misrepresenting himself to be of a full age and induces another person to lend him some money or to enter into a contract, can he be later on allowed to plead that such a contract is void because of the reason that when he was contracting, he was a minor, or whether in such a case section 115 of the Indian Evidence Act will apply. It is now settled by the preponderance of the authority that there is no such estoppel against the minor. The infant is not estoppel from taking up the defense of infancy. The policy of law is to protect the persons below the age from contractual liability, and naturally the doctrine of estoppel cannot be used to defeat that policy. Ratification. Since the minor's contract is void, he cannot therefore validate it by ratifying after attaining majority, for the obvious reason that ratification relates back to the contract. In an Allahabad case, a minor borrowed some money by executing a bond. When he became a major, he executed a second bond for earlier borrowed money as well as interest on it. The court held that the second bond was invalid because it was without consideration. Similarly, where a minor executed a promissory note after attaining the majority for the consideration he received during his minority, it was held that the promissory note was invalid because it was without consideration. Thus, from these two cases, it is clear that there is no question of ratification in such case. Specific performance of minor's contract. Since the minor's contract is wholly void, the question of specific performance of such a contract will not arise. Even the contract entered by the guardian of a minor on behalf of this is void and cannot be specifically enforced, but the agreement in favor of the minor are perfectly valid. In other words, an agreement which are beneficial to the minor are valid. The only difficulty is that the minor cannot claim the specific performance of an agreement, because specific performance, being an equitable remedy, can be granted only when there is mutuality. That is, when each party is entitled to the remedy. A contract may be entered into on behalf of a minor by guardian or by the manager of the estate. In such a case, contract can be specifically enforced by or against the minor in these circumstances. Number first, the contract is such that the manager is competent to enter into such contract on behalf of the minor so as to bind the minor. Second, the contract is for the benefit of minor. If either of these two conditions are wanting, the contract cannot be specifically enforced. The Privy Council in Mir Sarwar Jan versus Fakhruddin, Privy Council has held that the guardian of the minor has no power to bind the minor by a contract for purchase of immovable property, and the minor is not entitled for a specific performance of contract as there is no mutuality. In subsequent case, Babu Ram versus Saidun Nisa, court held that Privy Council ruling given in the above case is confined only to those cases where a contract has been entered into by the guardian on behalf of minor, and the guardian is not appointed under the Guardian and Wards Act. But if a guardian is appointed under the Guardian and the Wards Act, a contract by him on behalf of the minor for the performance of immovable property is valid. So, the case of a certified guardian of a minor selling the minor's property with the sanction of the court stands on different footing, and specific performance of such a contract can be ordered if the contract was beneficial to minor. Minor's liability under law of torts. Though as a rule, infant is not liable for a contract, but he is always liable in tort. In the words of the Lord Mansfield, I quote, "The protection of the infancy must be used as a shield and not as a sword." Unquote. Infant or a minor is generally no less than an adult in tort, But it must be carefully remembered that a tort arises out of a contract and a contract is not enforceable against the infant. He cannot be made liable by treating the breach of contract as a tort unless it can be severed from the contract. It is well established that an infant cannot be made liable for what was in truth a breach of contract by framing the action in tort. You cannot convert a contract into a tort to enable you to sue an infant. If it were the power of the plaintiff to convert that which arises out of the contract into tort, there would be an end to the protection given to the infant by the law. Contract of apprenticeship. Contract of apprenticeship is again a contract which is beneficial to the minor and thus binds the minor. In England, the contract of service and an apprenticeship are put on the same footing as the contract of necessities. Necessaries apply to minor, Section 68 of Indian Contract Act. According to Section 68 of Indian Contract Act, if a person is incapable of entering into a contract or anyone whom he is legally bound to support is supplied with necessaries suited to his condition in life, the person who has furnished such supplies is entitled to reimburse from the property of such incapable person. Unquote. The section contains these illustrations. A supplies B a lunatic with necessaries suited to his conditions of life. A is entitled to be reimbursed from B's property. A supplies the wife and the children of a B a lunatic with necessaries suited to their condition in life. A is entitled to be reimbursed from B's property. The liability is only for the necessaries, but there is no definition of the term necessaries in the Act. Thus, whether the particular goods supplied is necessary or not depends upon the facts and the circumstances of case. As pointed out by the Cheshire and Feefort, I quote, "The word necessaries is not confined to the articles necessary to support of a life, but includes articles and services fit to maintain a particular person in the station of life in which he moves." Unquote. Persons of unsound mind, Section 12 of Indian Contract Act. Besides an infant, a person of an unsound mind is also incompetent to enter into a contract. Section 12 of the Act provides as to what is sound mind for the purpose of contracting. It provides a person is said to be of a sound mind for the purpose of making a contract if at the time when he makes it, he is capable of understanding it and forming a rational judgment as to its effect upon his interest. A person who is usually of an unsound mind but occasionally of a sound mind may make a contract when he is of sound mind. A person who is usually of a sound mind but occasionally of an unsound mind may make a contract when he is of sound mind. Thus, if a person at the time of making a contract is capable of understanding it and of forming a rational judgment as to its effects upon his interest, he will be declared to be of a sound mind. Even a person who is usually of an unsound mind but occasionally of a sound mind may contract when he is of a sound mind. With this, I conclude this lecture. Hope you have understood. Thank you for watching.